Listen Up with Jim Potts. Listen up, business owners, CFOs, human resource managers, and all managers and supervisors. Jim Potts is answering and addressing your questions and concerns, helping you stay out of court. Furthermore, please be advised that Jim's answers are not legal advice and are only intended as a guide based on his years of experience. The phone lines are open, 1-855-4-J-POTS. That's 1-855-457-6887. You can also email us at listenup@jameswilliampottsllc.com. Ready to listen up? Here is Jim Potts.
Jim Potts back on the air. Well, hello everybody. Thanks for tuning in to me again. Whatever you're doing out there, running, jogging, swimming. Oh, you wouldn't be swimming; you'd be under the water. But at any rate, we appreciate you. We appreciate you tuning in and listening to me. Yeah, the title today is "No Good Deed Goes Unpunished." You know what? Let me tell you something. I'm always telling employers and managers that, and it doesn't mean that I don't have a good heart my own way. But when you're with these employees and you want to do good things for them, I understand that. I try to do good things for my employees as well. But there's so many times when the employer comes to me and says, you know what, I gave this guy money out of my pocket. I got baseball tickets and gave them to the Dodger game or the Angel games, for the person's kids. This one employer told me one time about the fact that the person was going through a divorce, didn't even have a bed to sleep in, and his employer went out and gave the person money to go buy a bed, and so the person wasn't sleeping on the floor. I mean, I've heard all of these stories. And guess what the sad part is? Those are the employees that come back sometimes and sue. I kid you not. And you're trying to tell clients, look, everybody's got to be treated the same. You've heard me say that before. Are you going to run around trying to buy, beds for all your employees? Somebody else finds about it. Somebody's going to be upset. I had one the other day. I was in a seminar and they're talking about this guy's attire, and they're talking about that this guy literally wears the same suit to work every single day. And they were talking about chipping in and buying this guy, a couple of suits or whatever the case may be. That was a good-hearted act. I have no problem with employers or managers and supervisors being good-hearted people. But you got to also understand that what you do for one, you've got to do for everybody. Now, I recommended it to them to go to, tell the guy go to a thrift store. You can go to a thrift store and buy a suit, or more pairs of pants, because they're saying he wears the same pairs of pants every day, blah, blah, blah. It's like, you know what? He can go in those thrift stores and buy, some clothes for reasonable prices. He's working a full-time job. $5 for a pair of pants at the thrift store, $10, whatever it may be. I would rather have you make that recommendation than to turn around and reach in your pocket and start handing employees money. Because to me, that only ends up being disastrous in one way or another. Because if you do it for one, you've got to do it for other. Now, what am I leading up to? Let me just tell you. There was a situation in the city of San Gabriel, and this is in California for those of you that are out of state or out of the country that's listening to this. But it's really the point of the topic for discussion today. Now, I'm going to give you basically an overview of what this is. Now, picture this. As an employer, you have health care benefits for your employees. All right? And let's say those health care benefits cost $500 a month for you to have, your portion for the employer to pay on behalf of their employees. But then you have some of the employees who are not on your health care benefits because they're on their health care benefit plan with their spouse, significant other, whatever the case may be. So they don't need your health care benefits. So what did the city of San Gabriel do? They turned around and said, you know what? To be fair, because employee A is getting the health care benefits, but the employee B is not. So here's what we're going to do for employee B. Because the benefit to employee A is that, they're getting $500 a month in health care benefits, the cost of the health care benefits. But because you're in this other plan, we want to be fair to you. So what we're going to do is give you $500 a month. Cash. Here, $500. And in their mind, this balances out the issue between employee A and employee B. Now, sounds fair? Absolutely, it sounds fair. It sounds great. Right until up to the time where employee B and other employees that were similarly situated turn around and file a class action lawsuit against their employer because when they were calculating the overtime for employee B and the other employees that were similarly situated, they didn't take the $500 into cash to determine the proper overtime rate. Their argument is that you take the $500, you add that to whatever we got, in the payroll period or the month, whatever the case may be. You add that, it boosts up our hourly rate. So when you're calculating the overtime rate should have been higher. So all of those hours that we worked overtime should have been at the higher rate that incorporated that $500 that you gave me for those healthcare benefits. Now, can you believe that? That's what I say, no good deed, goes. Listen, you got to understand, okay, that when you do things like that there are repercussions to that. And quite frankly, that's income. That's income to that. That's why you also have to be careful with giving gift cards, as an example. This business about giving somebody a gift card, giving somebody a Christmas bonus, all those kind of things, the IRS and the franchise tax board in California, they're all over that kind of stuff. So you need to think outside the box. Now, I recognize that here was a company trying to do things the right way. They were trying to take care of their employees. They were trying to be fair. And here they ended up getting sued for a completely different reason. I'm a firm believer, in fairness. I've worked for years to be able to give my employees 100% health care benefits, and I do that. But if somebody's on another plan with somebody else, that just works to my advantage. I'm not being unfair to that person because they elected not to take advantage of a benefit that I was offering them. So even though your heart was in the right place, Mr. Employer, you got to understand under California law. And by the way, this case went all the way up to the Ninth Court Circuit of Appeals, which is the one that handles any kind of decisions in California. So I want to... The issue was whether the cash in lieu of benefit payments have to be included in the regular rate. The Ninth Court Circuit answered that question in the affirmative, albeit acknowledging that it was a close call on issue of first impression. The court rejected the city's argument that the payments are properly excluded from the regular rate because the payments are not compensation for hours worked, which is true. They were not hours worked. But what did the court say? No, we're not buying into that. It was still a cash benefit to the employee. And remember, they're also relying probably on past decisions where they discussed the fact that things like these gift cards for $50 or $100 are passed out. That's income to the employee. So they're probably looking at it along the same lines. So from that perspective, you look at this and say, okay, here I am trying to be a good employer. I'm trying to treat my employees right. And as a result of that, what happens? I get a class action lawsuit from a bunch of ungrateful individuals who are just doing nothing but seeking additional compensation. But again, that's California. I've told my family back east, they're always asking me about whether or not I'm ever going to retire and move back east. And I keep telling them, as long as I live in California with all of these laws, I'm never going to be out of work. And that's the bottom line. And I will keep fighting on behalf of employers. I do have a positive attitude toward employees. So I don't want anybody writing me any hate mail talking about I'm all for the employer. Yes, I work with the employer, but remember something else, employees that are out there listening. I'm also encouraging employers to know the law, to do the things the right way. I'm encouraging employers to train their managers and supervisors so that they're not violating your rights as well. So it works out, it works out from that standpoint. Now, you heard me talking about some laws. Well, in the past, I've talked about some laws that were pending. I just want to give you a heads up. There's a new wave of what I call wage and hour retaliation claims. Watch this one. Because what employees are doing, I've gotten 3 of these in the last few weeks, where employees are now going and they file a regular labor board claim, we'll say, but then they want to say they complained about something with their wages, even if it was some comment. Oh, I don't think my check was right. You shorted me by 50 cents, whatever it may be. Okay, and they fix it. Now they end up losing their job. They're coming back saying that the reason why I got fired was because I complained about my check. This stuff's getting out of control. Now, there's some new laws that I've told you about that were pending, and here's a couple that were actually passed the first muster, so they've achieved their first level, and they're moving forward. One of them you need to check out is called AB 2261. This bill will add to the section 98.74 to the California Labor Code and now allow the Labor Commissioner to conduct an investigation, issue citations, or bring a civil action against an employer for labor code violations, even when no employee has even filed a complaint against the employer. That means what this is suggesting is that the labor board's going to be able to go out to some place, conduct some investigation at their will, at their whim, and now bring an action against the employer if they don't find everything correctly, that's being correctly done. I mean, to me, what is that? That's headhunting. And what else are they doing? They're looking to line the state's pockets. Why? Because these states need money. What are they going to do? They're going to try and get it out of the employer. So employers out there, this to me is one of the ones that's most concerning. I'll give you another one very quickly. This parental leave bill, SB 1166, this bill would require all California employers with 10 or more employees to provide up to 12 weeks of unpaid leave to an employee who has at least 12 months of service and has worked 1,250 hours over that 12 months for the purpose of bonding with a new child within the first year of the child's birth. Also for adoption or foster care. Do you understand that one? 10 employees. The law is 50 employees or more. Now they're dropping that number from 50 down to an employer having 10 employees. Now, what does that do for a small business owner that's got, 10 employees and you have 2 or 3 people that could possibly go out at the same time? The impact on that business. Some of these laws are just totally insane. Now, this hasn't been passed yet, but it's already passed the first level. It's going to the next level. I will keep you posted on that one as well, because the majority of the employers out there are the small business employer, and this is going to have a significant impact if you've got under 50 employees with more than 10 or more. All right, with that last comment, it's time to close out this segment, but let me remind you that you can also hear us on Facebook at Listen Up and subscribe to us on iTunes. Just search for Listen Up with Jim Potts. And as a reminder, we take calls every third Friday, roughly 9:45 to 10:15, 10:30-ish. And you can reach us at 855-4J-POTS or 855-457-6887. Or you can email us, as so many people do, at jameswilliampotsllc.com and send us an email. All right? Okay, I'm Jim Potts, and I will continue to fight the fight. Thanks for listening, and I will catch you next time.
Thank you for being a part of Listen Up with Jim Potts. We take your calls every third Friday at 10 a.m. Pacific Standard Time for your questions and concerns. Call us at 1-855-4J-POTS. That's 1-855-4J-POTS. Again, that's every third Friday at 10 a.m. Pacific Standard Time at 1-855-4J-POTS. Like us on Facebook, subscribe to us on iTunes, and link up with us on LinkedIn. You can also email us at listenup@jameswilliampottsllc.com. Until next time, make it a great week.